Welcome. I'm Patricia Gonzalez, an employment lawyer with Parley McLaws. Today, I want to talk about a term that many non-lawyers hear, but which few fully understand, and that is wrongful dismissal. It is my hope that by the end of this video, you will have gained a better understanding of this legal principle. In my last video, I explained that an employment agreement is a type of contract that is governed by the law of contract. As in any contract, an employee and an employer both have the right to end the contract, and ending it is not a breach of contract nor tort. In fact, Mr. Justice Cote of Alberta Court of Appeal, in the decision of Soust and Merrill Lynch Canada, Inc., hit the nail straight on the head when he said, "We speak of wrongful dismissal or damages for that, but there is no such thing as wrongful dismissal. Apart from federal legislation, under a contract of indefinite hiring, either side may validly end the contract at any time. The employee neither has tenure nor is indentured. What this means is that an employee does not have a right to a position for life or until retirement, where he or she can only be dismissed for just cause, a concept that will be the subject of another video. Likewise, an employer does not have the right to force an employee to continue working for it, like an indentured servant or a slave. So, if an employer can end an employment agreement, what makes a dismissal wrongful? Well, the law has developed in such a manner that it is an implied term of each employment agreement that unless there is an express term to the contrary, it is for an indefinite term, meaning that the employment agreement is intended to last for an indefinite period of time, with no specified or foreseeable end to the employment agreement. These contracts are referred to as indefinite employment contracts and are the default. An employee working under an indefinite employment contract can only be terminated without cause as long as he or she is provided with reasonable notice of termination, which means that an employer has an obligation to provide the employee with notice that the employment agreement will come to an end at a certain date. The amount of notice that an employer is required to give when it terminates an employee without cause is determined in two ways. The first is through the common law, which was and continues to be developed through decisions made by judges. And the second way is by a term in the contract that states how much notice the parties agreed that the employee would receive as long as it complies with the Employment Standards Code and is drafted in such a way that the courts will enforce the term. Now, some employment agreements are fixed-term contracts, but I will not be discussing those today, but will cover them in a later video because different rules apply to fixed-term contracts. In summary, an employer commits a wrongful dismissal when it terminates the employment of an employee without cause or without the amount of notice to which the employee is entitled to at common law or by the express terms of the employment agreement. If you are an employer who is considering terminating an employee on a without cause basis, or an employee who has just been terminated on a without cause basis, you should really consider contacting an employment lawyer to ensure that you are either providing or receiving sufficient notice of termination. Until next time, thank you for joining me and learning more about employment law in Alberta.